This is Barry Zalma speaking for my blog, Zalma on Insurance. Today we speak about why no good law will go unpunished by people who are intent on committing fraud, and why unalleged, no-fault fraudsters were enjoined from claims, arbitration, or suit to collect no-fault benefits, and why the no-fault fraud was enjoined. In Allstate Insurance Company and its various entities versus Jonathan S. Landow, MD, and multiple doctors and healthcare providers, the United States District Court for the Eastern District of New York on March 30, 2026, responded to plaintiff's 187-page complaint, including dozens of pages of exhibits detailing a scheme of kickbacks for patient referrals, operation of clinics by laypersons, lack of medical care provided by the medical doctor defendants, and predetermined and trumped-up medical treatments. Allstate plaintiffs sued multiple defendants, including physicians, medical professional corporations, and managerial individuals, called the defendants. The plaintiffs allege that the defendants collectively participated in a scheme to defraud them by exploiting New York's no-fault insurance system, submitting illegal and inflated medical costs through various medical professional corporations. The action involves claims of violation of the Federal RICO Act, common law fraud, and unjust enrichment. Allstate sued Landow and the rest of the defendants, and the suit alleged violation of the Federal Racketeer Influenced and Corrupt Organizations Act, RICO, common law fraud, and unjust enrichment. The Allstate plaintiffs also alleged that all defendants collectively engaged in a scheme to defraud the plaintiffs via New York's no-fault law. The case centers on New York's no-fault statutory framework, which is designed to provide prompt compensation for necessary medical expenses resulting from motor vehicle accidents up to $50,000 per person. The laws allow claimants to assign benefits to licensed healthcare providers who then submit claims to insurers for payments. Providers must be operated by licensed professionals, and any fraudulent activity, including submitting materially false claims or receiving kickbacks, is prohibited under relevant New York statutes. Failure to comply with licensing requirements renders providers ineligible for reimbursement. Plaintiffs sought a preliminary injunction to stay all current no-fault arbitrations and prevent defendants from filing new arbitrations or state court collection suits during the litigation. The court reviewed the statutory requirements and allegations, focusing on whether defendants' conduct violated the no-fault laws and related regulations. A party seeking a preliminary injunction, like Allstate, must show 1, irreparable harm, 2, either a likelihood of success on the merits or both serious questions on the merits and a balance of hardships decidedly favoring the moving party, and 3, that a preliminary injunction is in the public interest. The court examined the statutory prerequisites for medical providers to claim no-fault benefits, emphasizing the necessity of licensure and prohibition of fraudulent practices. Plaintiffs' allegations that the defendants operated unlicensed or fraudulently managed medical corporations and submitted improper claims were found to raise serious questions under both federal and state law. The procedural history and unopposed motions supported granting the requested relief. In conclusion, the court granted plaintiffs' motion for preliminary injunction in its entirety, staying pending no-fault arbitrations of state court litigation against the plaintiffs and enjoining the defendants from initiating new proceedings during the pendency of the action. The decision underscores the importance of compliance with New York's no-fault laws and the legal consequences for fraudulent or unlicensed conduct in the insurance and medical services context. Plaintiff's motion for preliminary injunction was granted. In my opinion, the no-fault law was created to avoid litigation, make benefits available promptly, and avoid fraud. Unfortunately, it created a cottage industry for fraud perpetrators who created fake medical bills to obtain the maximum recovery for people who were either uninjured or modestly injured, and for healthcare providers who had no morals nor willingness to follow the law. Allstate and other insurers are using injunctions to take the profit out of the fraud, since the authorities seem to have failed to prosecute the scofflaws. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll gain access to the more than 5,300 blog postings. You can also subscribe to these videos on YouTube and rumble.com. They're free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.